Hello, everybody. It's Ed Rosenberg, and this afternoon I am speaking with CJ from Amazon Sellers Lawyers. CJ, once again, how are you?
I'm doing great, Ed. Thank you very much again for having me on the show.
Okay, my pleasure, CJ. And again, we're going to jump right into it. I've seen an alarming amount of rights owner infringement claims against Amazon sellers recently. You want to let me know what that's all about?
Sure. We're also seeing a tremendous increase in the amount of intellectual property complaints being asserted by big manufacturers as well as smaller brands. There are a lot more companies specializing in what they call brand protection and people who are getting to the business of trying to sweep listings. And what they're making a lot of baseless complaints, a lot of baseless intellectual property complaints against sellers that we represent. And what we're trying to do is to obtain the retractions of those complaints to get our sellers back to their business of selling products.
Right. Now, tell me the different types of infringement. I know infringement is a whole class of it's just a category. Give me a few examples of specific types of infringement by companies that complain to Amazon, which is us kicking off Amazon sellers.
Sure. There are basically three different types of infringement claims. They're all based on intellectual property law. There's trademark claims, there's copyright claims, and there's patent claims. Patent claims are the least common. A patent really protects an invention where you apply to the United States Patent Office and you get the government's permission to be the sole maker of that particular invention, like for a heart defibrillator or a new drug or something that the government wants to inspire people to invest in. So you give them protection against other people selling that product. Those claims against Amazon sellers are pretty few and far between. Much more common are the copyright and the trademark complaints, and these happen. We're getting a dozen calls a day of these things. A trademark is like the Nike swoosh on your shirt, or the red and white circle from Target, or the way the K is written on Kmart or the M in McDonald's. It indicates a particular brand. And trademark complaints, what we're seeing are companies are making trademark complaints, not where people are taking the Nike swoosh or the K and putting it on a fake product, but actually selling the real product. And those complaints are baseless. There's no trademark complaint. There's no valid trademark complaint if you're actually selling a Nike good with the Nike swoosh on it. Those are baseless complaints. And the United States government recognizes people who and companies that make these complaints, and they call it trademark bullying. Another category of complaint are copyright complaints. Copyright protects creative works, writing, plays, movies, pictures, comedy routines, ways of saying certain things. Those are all copyright material. And we're getting a lot of those complaints as well, where the manufacturers are claiming that our clients are using words or phrases that they have drafted and put on their products. And those are the main categories of complaints that Amazon sellers are now facing every day: copyright and trademark.
Now, why does Amazon, as soon as they complain, why do they kick off the seller without even giving him the opportunity to disagree?
Well, I think Amazon is doing it because they want a hands off and they want no liability on themselves. Through your participation agreement, you can't go after Amazon for your lost earnings or your lost profits. So when they get any complaint, what they're doing is they're knocking the ASIN off, knocking that seller off the ASIN, or even suspending a lot of sellers to protect themselves from having a claim, by Apple or Kmart or Walmart against Amazon for allowing counterfeit products. And what Amazon has done, I think it's terribly wrong, is they've reversed the legal process. Normally, if Nike or Apple or Kmart or McDonald's thought someone was selling one of their products, they would have to go to court and show first that there was infringement, and then there would be some punishment. Amazon they've reversed the roles, and they're actually taking any complaint, whether it's meritorious or baseless, and they're knocking sellers off.
Right. And basically what's happening is these big brands, they're taking advantage, I think, of Amazon's rules because they know if they go to court, it's too long of a process and they'll probably be laughed at anyways. So what they're doing is they're taking Amazon's rules and they figured out a way how to kick off small-time sellers.
That's exactly what they're doing. And I think a lot of the sellers, they need someone to stand with them. We've been remarkably successful in getting brands large and small to withdraw their complaints because we show them that they're baseless. And when you show them that they're baseless, you can put them on the spot and say, you're potentially liable now because you're engaging in unfair trade practices, you're violating federal law, you're violating state law. And also the power of the press and the power of the internet is very, very helpful because they don't want to be shown to taking a mom and pop or a single mom or any small time seller or someone who has employees and taking away their income on their baseless allegations. In every state in the union, when a lawyer is involved, that lawyer has an ethical obligation not to maintain a baseless complaint that hurts somebody. So we're using state and federal law, we're using the ethical rules against lawyers around the country to get them to withdraw these baseless complaints.
Now, why would a company care if if I'm selling an Android or an iPhone and I say this case fits an iPhone 6? So they say I'm using the word iPhone 6. I mean, how else am I supposed to say that?
Well, that's one of the problems I think at Amazon, and I'm in the process of reaching out to some lawyers that work for Amazon to try and address this. They're very leery of the phrase compatible or synonyms of that because they're afraid that the consumers are going to think that compatible means it's actually made by Apple. But there is no copyright infringement, there is no trademark infringement by saying that your particular case fits an iPhone 6. There's no violation of anything.
Yeah, I mean, if I have a hotel and I put in the advertisement 2 blocks away from McDonald's, and McDonald's can sue me that they own the word?
No, absolutely not.
Right.
Absolutely
so it's exactly what's happening here. So I just, anyone that's watching it and just my perspective, I think what's happening here is the companies don't want these small sellers selling their products for whatever reason. So they put in an infringement claim, and they see that, and Amazon wants to make sure that Amazon is known as a place where big companies are not angry at them. So they put in a complaint to Amazon, and then Amazon sees, oh boy, this big company is complaining that this seller is infringing. Let's get rid of this seller, and you two fight it out. And Amazon is not really taking sides, but in the meantime, you're suspended.
In reality, Amazon is taking sides in a way because they're taking baseless allegations and they're hurting sellers. The way you can deal with it, I think, as far as I'm aware, I'm the only person that's been able to get people reinstated without retractions, because when you reach out to the rights owners, they either show that they're baseless or they don't respond. And what you could then do is take your repeated correspondence. I also provide legal opinions, and you can send that in with your plans of action. And I wouldn't say it's a slam dunk, but we've certainly gotten sellers reinstated without the retraction. It's much easier with the retraction, but we've been successful on both sides.
Right. Now, I've spoken to sellers who are facing this. I know you certainly have. And normally, as soon as the seller hears that there's a particular company that's complaining, by the way, they say, no problem, we'll take this for you off, we'll never sell it again, and just we'll make an agreement with this company that will never, ever, ever sell this item again. All we want is you to send a letter to Amazon that you were sending the complaint, and Amazon will be okay with that. Now, what would be a motivation for a company not doing this? Just punitive?
I think the motivation is punitive in nature. I think they want to scare people. They want to limit the marketplace. They want to take the small guys. I mean, sellers like the people who are listening to this and my clients are really taking a bite out of big corporate America because they're able to sell for less in many fashions. So I think it's an across the board change in how they want to do business. They want to try and take out the little guy who can suddenly compete, worldwide.
Right, because there used to be like these few mega companies selling hundreds of different categories, and if you weren't one of them, you couldn't really compete. Now you have all these private label niche sellers building these huge brands on Amazon, eBay, Facebook, Instagram, and it threatens those major companies their niche, because I could do it just as good. The warranty is just as good. The product is just as good. The packaging is just as good. And maybe I'm not going to have the NBA star, and I may not have the name, but everything else is the same. And to me, it seems, unless any other company wants to come up and say your side of the story, they're welcome to come on. But that's what it seems like they're trying to do here. Would you agree?
Yeah, I do. I agree 100%. Because they see the threat that hundreds of thousands and millions of small business people, and what they're able to do in terms of getting in the marketplace and beating them at their own game. So I do. I think it's a phenomenon that we have to address. But we certainly have some positions of strength, because from what I'm seeing, the vast majority of the intellectual property complaints are baseless. It's the retail arbitrage seller who is buying goods at Walmart and buying several different brands and then just taking those brands and putting them up on the platform. And by doing that, there's no change, there's no alteration, and it really is a real Danskin product or a Nike product. There's no complaint. And it goes also for the people who are buying from liquidators. If you're buying Apple, if you're buying Apple phones from various distribution channels and they're real Apple iPhones, there is no trademark or copyright violation. It doesn't exist. And those companies have no right to stop sellers.
Now, what would happen if a seller would actually go to court? Who would win?
It would depend. I would think most of the time the sellers would win, because the complaints are baseless. If you're talking about the seller that's buying a genuine product from wherever he's buying it in the stream of commerce, if it's genuine, there is no grounds for the complaint, and the seller should win. Okay? If it really is a counterfeit product, it's different. But most of the sellers I'm seeing are not selling counterfeit products. They're selling genuine products, and then you have the manufacturers that are brand managers who are trying to take them out. So I think in court we'd be very successful. Also, there is strength in numbers. Currently, I'm putting together a group of sellers who are having problems with Apple. And Apple is being really, really aggressive, overly aggressive. When I believe they know the products are genuine, they're just trying to knock sellers out. They're immediately getting the lawyers involved. It's a New York City firm. I speak to the lawyer probably once or twice a week right now. And I think it's time that sellers group together. The Apple sellers who've had complaints or been suspended, even maybe for one ASIN or a handful of ASINs, should group together and stand up to Apple, because it does a couple of things. It shows Apple that, one, you're just not going to take it anymore. It drops the cost per seller dramatically, because my time as the attorney doesn't go up exponentially because I have 5 or 15 clients. The cost is the cost, and now it's being split by 5 or 15 or 20 different sellers. The cost will be minimal. Also, what it's going to do, Apple specifically, that I got to say, that's who I'm working on. That's who I'm really gearing up towards right now. Apple was going to have to show for every single cable, every single plug, every single phone that they claim was fake, they're going to have to show what's called the chain of custody, where they got it from, how to get from the mailbox to their office, who tested it, where are their notes, is that person available to testify? And then they're going to have that product available for me to look at. And this is going to be a tremendous pain in their neck. They probably didn't do it. They're probably disposing of things that they test. Their testing is probably flawed, and they're probably not tracking it properly. So when they can't show for each and every item, then those claims are going to get tossed out, and they're going to be shown to have no grounds for infringement, and that will open the floodgates to lost earnings and unfair trade practices, and what the United States Congress calls trademark bullying.
Right. Now, how about, what would they say to the other response about using the word iPhone?
There's no infringement. It's a word in our vernacular. It's really an iPhone product. You can call it what it is. There's no infringement. It doesn't exist. The claims are nonsense. I think eventually Amazon will have to shift the way they see these things. But Amazon has kind of protected themselves with the participation agreement as to how you can go after them. So their strategy, I think, for now is good. The targets, I think, are the people making the false complaints with the knowledge that they're taking small business people out of business.
Right. And just to clarify, if you're really selling counterfeit, right, we're not talking about that, of course. And I'm sure there are plenty of people selling real counterfeit apples, so of course they have a right to go after them. We're talking about here just using the Amazon rules to pretty much suffocate small Amazon sellers, and they're assuming that no one's going to have the nerve to go up against Apple. And this is the situation we have now, where any lawyer just sits there and pretty much tells Amazon that this small seller is infringing. Amazon says okay, and that seller just withers away. That's what they're hoping, I believe.
The vast majority. I also got to tell you, I'm not a big fan of litigation. I don't think litigation is in our client's interest. But you can also stand up and show strength without getting into litigation. And I think that's vital. That's where we've been successful. When there's a lawyer to a lawyer and they're pointing out, by the way, you're the one that made the complaint and it's baseless. I know it and now you know it. You have to take it down. It's very effective. I don't want your listeners to think that anyone's racing to court. I try to avoid court at all. If at all possible, we avoid it. But I think coming from a position of strength and pointing out to them, saying there is no copyright complaint, there is no trademark complaint, you must withdraw or else you're putting yourself in harm's way. That's how we've been successful.
Mm-hmm. Wow. Is it possible that what these companies are trying to do is, like, you hear the name Apple and you don't even think about selling the name Apple? I think it could be. In other words, they're purposely putting up this image of being ultra rough. And this way, when a distributor offers me Apple, I'll say, no, I don't want to touch Apple.
It could be. It could be a long-term plan. I think right now they're counting on people not standing up to them. I mean, most sellers, all they want to do is to get back to the business of selling. If that means dropping the lightning cables, they're willing to do that. I got to tell you, that for Apple in particular, we're talking a lot about Apple. Apple right now is refusing to withdraw their complaints, even for the lightning cable. Even in a case where I pointed out to Apple it wasn't my client's product that they purchased, they're still refusing. So would I say stay away from Apple products? I don't think I would say that, because they're very profitable. You're not doing anything wrong. But if Apple does, I think you need to stand up to them and point out to them, I'm not doing anything wrong. You have to withdraw your complaint. You're the one that's doing something wrong.
Right. Now, what would be the reason why smaller companies, because I have had some situations where, this brand would say, look, we don't want you online. And right away the seller would say, no problem. And, if the guy is a decent person, he would, just do the agreement. He's getting what he wants anyways, that the seller is not selling. And the seller will remove the listing. And then this guy, he can get back to the business of selling back 98% of the products. So what would be the reason, besides for a huge company who wants to flex their muscle, what would be a reason why a smaller brand would do that?
I haven't seen a smaller brand do that. I haven't seen any of the smaller brands refuse to take to retract their complaint when a seller simply says, I'm just not going to do it. I haven't really seen that. Apple is the one that I've seen being the most stubborn. Apple is the one who's immediately having lawyers contact sellers with a whole list of information that they're looking for before they'll even talk to you. Apple's the one that's not revealing that their policy is to refuse to withdraw the complaint. So it's Apple's different than the others. I've had manufacturers, big and small, from Cisco to Walmart to very small cosmetic manufacturers, all agree to withdraw complaints so that people can continue to earn a living and support their families.
Right, which is all what we're trying to do. Okay, CJ, there's one thing before I let you go. Patent. How do I avoid patent? I find very tricky because, sure, the example you said, or let's say a segue. So I know I can't make a segue if it's patented. But a lot of times the patents are just like by me personally, like I've gotten some letters that the clamps which clamp a certain way are patented. And is there a way to know that before you order the products? You could invest, a lot of money on a private label product, and all of a sudden you get a nice letter that you're violating the patent. How do I avoid that?
The United States Patent and Trade Office, USPTO, has a pretty easy to use website. It's not the best looking or the simplest looking website, but for a clamp, for example, you could put in the words for the clamp, and I know in your case it's motorcycle audio equipment, and you could put in descriptions of it and pull up a list of the patents that do exist and to see which ones may or may not conflict with what you're either having manufactured or you're selling, and protect yourself that way. If you're unable to do it, we do that all the time. It doesn't cost a lot of money. And for a few dollars, you can really protect yourself probably 70, 80%, 90% of what you can get for spending a lot of money. But you can do these things yourself. If anyone would like to call me, if they'd like to have one of my people show them how to check their website, it's not very difficult. And it's a nice, easy, inexpensive way that you can get a lot of protection for yourself.
So this is all public information. Anyone can go on and you could have seen.
Oh, yeah, it's 100% public. It's run by our government, which is why the website is not so pretty. But it works.
Right. Okay. I really appreciate it, CJ, and have a fantastic weekend. Thank you so much.
Great. Thank you. Nice seeing you again.
Okay, bye.